perform any other functions of the president as the president may assign. 4, unlike the vice president who was appointed by the president from among cabinet ministers who are elected members of the National Assembly, the deputy president under the 2010 Constitution is elected together with the president and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and P.L.O. Lumumba, this is the second edition, Strathmore University Press, there 2019 at page 453. The two eminent authors had this to say, and I quote, "With the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitution review process, the CKRC noted that the powers granted by the constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president." End of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the Deputy President has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the President. Article 172 grants the Deputy President specific constitutional functions in addition to any duties the President may assign. This provision was intended to address the previous situation in which a President could, for any reason, choose not to assign any duties to the Deputy President, effectively sidelining them. Thanks to the 2010 Constitution, even if the President does not assign any additional duties, the Deputy President still has specific constitutionally mandated functions to perform. In this way, the Deputy President is no longer at the mercy and the discretion of the President. Under the current constitutional framework, when the office of the Deputy President becomes vacant, two outcomes flow. First, any functions that were assigned to the Deputy President by the President automatically revert to the President. Second, the functions expressly conferred upon the Deputy President by the Constitution do not revert to the President and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the President could appoint a minister to act as Vice President in the Vice President's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the Deputy President is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President will remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the Deputy President cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy president. Returning back to Article 146, which article deals with the vacancy in the office of the president. Sub-articles 1, 2, and 3 of that article provides that follows. These ones I'll read. Sub-article 1, the office of president, read deputy president, shall become vacant if the holder of the office A, dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of president on grounds of incapacity, or Article 145, which deals with removal of president by impeachment, or under any other provision of the Constitution. Sub-article 2, when a vacancy occurs in the office of president or deputy, 1, the deputy president shall assume office as a president for the remainder of the term. 2, if the office of the deputy president is vacant or the deputy president is unable to assume the office of president, the Speaker of the National Assembly shall act as president, and an election to the office of president shall be held within 60 days after the vacancy arose in the office of president. Sub-article 3, a person who assumes the office of president under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected president is sworn in following the next regularly scheduled election under Article 136, sub-article 2A. End of sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumes the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy, as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gachagua'S Peter Munywa and Dixon Mwenda Githinji and 2 others said as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, sub-article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office, end of quote. 2, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No. It was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered nugatory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process
further calls upon this honorable court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
it's an application.
Mr. Jero has referred to an application for which he's seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamotho was keen to read the rules, the Mutunga rules allows me to move you informally, and subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
My Lord, if I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. Mr. Kamina, sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functas officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)(b) of the Appellate Jurisdictions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application before the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my learned friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. They are before the Court of Appeal.
So, may I suggest, Professor Gender, that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application, yes.
Thank you, Lordship. Your Lordship, permit me to move on with my application, and I urge Professor Ogenda to have a look at the rules that I have just referred to, that Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lords, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the president or the deputy president must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designate or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your Lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC.
My Lord,
we all know, my ladies, my lords.
My Lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our clients. So we'll be seeking that we get a formal thing that will enable us to seek instructions from our clients. Dr. Kamodo, for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordships. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiro, my understanding, when,
yes, Your Lordship.
When you first asked for this conservatory order,
yes, Your Lordship.
under Madu paper,
yes, Lord.
That
is his application.
Yeah.
I have on a different application. I moved under Article 23.
Because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship, I am well guided.
So I think for the purposes of the discretion of the
yes,
bench,
Lordship.
For the purposes of the discretion of the bench,
yes,
I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24, that due to the vulnerability of the rights and the vulnerability of the infringement and the violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have
not
my
rights.
time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sun, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki, on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you'll be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My Lord, let me respond to... can I respond?
Professor Ojenda and,
yes, my Lord.
And every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
Yeah, my Lord, if I may respond, my Lord.
My Lord, kindly, with your permission. With your permission.
My Lord, you've made a ruling.
Okay. Okay, let me hear two people from this side.
Okay, then two from... You're one person.
Dr. Kaminwa, please say what you want to say and be mindful of time, please.
Justice Eric Ogola, Justice Anthony Murima, and Justice Frida Ugandi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done so. You have developed this country. But there is one thing I would like to point out to you very first. That we are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom, we have to call for deeper understanding of human nature, and for deeper understanding of the society in which we live, Kenya. And what I'm saying to you is reflected in my broad pleading of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for books from India straight about 11 volumes on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will consider or continue to promote stability in the country? And it is here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. Zegwa, that we should not, and my friend Mr. here, we should not ignore what they are saying lightly at all. With a tremendous respect, we don't want to move out of this courtroom and then all of a sudden we are told that they have put us down in My Lord, I'm not trying to keep saying with
just hold on.
All that I'm saying to you, Your Lord.
Sorry, my lords. The utterances by the Honorable Dr. Kaminwa council are. I'm giving you the titles.
No, what I'm saying, let me say what I'm.
Unfortunately, they're inciting, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
My Lord, I was to also, you indicated that two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
No, my Lord, I'm actually showing one sentence. When you read the rules, I have referred to authorities in America. The judges have made a finding along this line. Yes, this is a bit of so and so is guilty, but we cannot go ahead. We shall do it. So that's all I'm saying to you. You have heard, you have come up with a very, if I may say so, a ruling full of jurisprudence, and particularly my land, Lord Gachagua'S has come up with something that I had not thought of very much at all. But all that I'm saying to you that you agree, but you still have the discretion to say that, look, we are not, we have these are our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion. For the sake of the country. Thank you.
My Lord, in brief response.
May I kindly, my name is Sam Nyaberi. I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord, my Lords and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition, we had named the Professor Kithure Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned